Welcome to everybody, wherever you are, and thank you for joining this webinar on what's left of international law after UN Security Council Resolution 2803 on Gaza. I am Lynn Welchman. I am a professor in the College of Law, SOAS, University of London. But this webinar is being convened by the SOAS Centre for Palestine Studies. I'm very grateful to the chair of the Palestine Studies Centre, my colleague, Dr. Nimel Sultani, for inviting me to chair this panel, and also to Aki El-Burzi for all the work in getting things set up, although at the moment, Nimr is at the controls. We're going to examine the substance and the implications of UNSCR 2803 of the 17th of November 2025. This resolution endorses the US-led comprehensive plan to end the Gaza conflict a few weeks earlier. The question, what is left of international law after this resolution, is provoked for and sometimes asked of many scholars of both human rights and international law, as well as, for example, those trying to use it, notably Palestinian human rights organizations and activists who work to lay claim to the protection of international law and to mobilize its prevention, accountability, and reparation mechanisms in the face not only of decades of settler colonial violence, apartheid, and illegal occupation from the Israeli state, but now also in the face of and in defiance of the genocide in Gaza. We are clearly in a moment in the history of engagement at the UN with Palestine, and a moment in the history of international law. And we may come to that with the questions. So, we are very fortunate to have with us two most knowledgeable and articulate panelists to reflect on this question. They have both written on this in different articles and been interviewed and so on. And I would encourage you, if you haven't done so already, to look them up and track down what they've been saying. It's very informative. So what's going to happen is, firstly, I will introduce our panelists, Craig Mokhiber and Jonathan Whittall. And then each of them, will speak for some 20 to 25 minutes. And I will answer, possibly with some questions, possibly with an additional intervention. And they can also talk to each other should they wish to. And then we'll have the Q&A facility, which will be open if you out there have any questions for the panel as a whole, or for particular panelists, in which case you can address it to a particular panelist, or simply leave it open to be addressed by any of either of them, and also me if I have any ideas on how to answer. If you have questions, do put them in the Q&A, the question and answer facility. That's where you put it. We don't anticipate not being able to answer all the questions. So we hope we'll get lots of questions, but we are afraid in advance that we won't be able to answer all of them. So we beg your indulgence if your question is put and not answered. I'm now going to introduce our two panelists, and then I'll turn it over to them to speak. Our first intervener is going to be Craig Mokhiber, who is an international human rights lawyer and activist, and a former senior human rights official, most latterly directing the New York office for the United Nations High Commission for Human Rights. He holds a BA in political science and a Juris Doctor from Buffalo, and was admitted to the Bar of the State of New York in 1991. He spent the 80s in human rights work as an activist, and then for over 3 decades, he worked at the UN in human rights, serving in Switzerland, Palestine, Afghanistan, and the United Nations headquarters in New York, in posts there, and undertaking separate missions of human rights missions around different parts of the world. In October 2023, he left the UN, publicly publishing his resignation letter, which was very critical of the United Nations' human rights failures in the Middle East, a warning of the unfolding genocide in Gaza, and calling for a new approach to Palestine based on international law, human rights, and equality, very much the subject of this seminar. Our second panelist, Jonathan Whittall, is quite recently, again, the executive director of the Keys Initiative, and holds a PhD in humanitarian studies. Until recently, I think this summer, he was acting head of the United Nations Office for the coordination of humanitarian affairs, which you will probably know as OCHA, in the occupied Palestinian territory, where he led the humanitarian negotiations unit. Before this, he was also at OCHA in the OPT, he was head of the West Bank Field Coordination Unit and interim head of research and analysis. And before that, he worked for some time with Médecins Sans Frontières, MSF, which will be well known to all of you, in several senior roles on humanitarian analysis and humanitarian response. To support improved operational strategies and advocacy, and to directly implement negotiations for humanitarian access, which again is something, of course, extremely relevant to this seminar. Among other conflict contexts, he supported MSF operations on humanitarian access in Iraq, Afghanistan, Lebanon, Syria, Ukraine, and South Sudan. I'm very pleased to welcome them both. It'll be good to hear in these dreadfully difficult times your opinions of the question and of the resolution as we start. Over to you. Welcome to this webinar, and thank you very much for joining us. Craig and then Jonathan. Craig?
Thank you very much, Professor Welchman. Thanks also to Jonathan for being here, to Nima and to all the organizers of this event. Well, I've written about this resolution 2803 in the UN Security Council as being a moment of shame for the United Nations, in which the UN appears to have gone full colonial. 2 years into the genocide, in which the Security Council had been unable to act, it finally took action with this resolution. But rather than enforcing international law, protecting the victims, holding the perpetrators accountable, it adopted this resolution that I have said openly flouts key provisions of international law, punishes the victims and survivors of the genocide, and rewards and empowers the perpetrators of the genocide. And most disturbingly of all, it effectively has handed control of Gaza and the survivors of the genocide over to the United States, which is a co-perpetrator of the genocide, and provides explicitly for the participation of the Israeli regime in decision-making on this new colonial endeavor. Palestinians themselves are guaranteed no such participation under this plan. It is effectively a mechanism of Israeli and US oppression with a UN stamp of approval. And what I've said about this is, not since the UN purported to partition Palestine in 1947 against the will of the indigenous people, which set the stage for 80 years of Nakba, not since then has the UN acted in such a baldly colonial, and I will prove as well, unlawful and ultra vires way, and trampled so recklessly on the rights of a people. This resolution, I won't go into it in detail, but maybe during the Q&A we can talk about it, but it effectively hands control of Gaza over to a US, in fact, a Donald Trump-led colonial body that they have attached the Orwellian name of the Board of Peace to, while also deploying a proxy occupation force, also directed by the US, that they call the International Stabilization Force. Both of these bodies answer ultimately to Donald Trump himself. Both of them will involve consultations with the Israeli regime, the perpetrators of the genocide, the perpetrators of the unlawful occupation, the perpetrators of a regime of apartheid. And the UN Security Council allowed this to pass, 13 of the members voting in favor of it, and Russia and China that could have vetoed it on behalf of the Palestinians, but on behalf of international law as well. They both abstained, didn't use their vetoes, and allowed it to pass. One of the remarkable features of this horrific resolution, this stain on the United Nations, is that it implicitly rejects all of the recent findings of the International Court of Justice. It openly denies Palestinian right to self-determination. It reinforces the Israeli regime's impunity, even as the genocide continues. And let us remember, the genocide in Palestine has not stopped. There is no ceasefire. There has not been a ceasefire for a single day of this so-called ceasefire period, where in fact Israel has continued to murder hundreds of Palestinians, to destroy hundreds and now thousands of civilian buildings, to block thousands of trucks of much needed medicine and food, and to continue the genocide as well into the West Bank. Despite the findings of the International Court of Justice that the Palestinian people have a right to self-determination, This resolution strips that right away and empowers hostile foreign forces to govern over the Palestinians. Despite the findings that Gaza, as well as the West Bank and East Jerusalem, are illegally occupied and that the occupation must end quickly and completely, this a finding of the International Court of Justice, this resolution extends the Israeli occupation, endorses the indefinite presence of Israeli regime troops in Gaza, and then superimposes a second US-led occupation on top of the Israeli occupation with which it collaborates. And despite the findings that the Palestinians don't have to negotiate for their rights with their oppressors, as the ICJ has found, and that no agreement or political process can trump those human rights, this resolution effectively nullifies those rights and assigns them to the discretion of the United States and to its Israeli and other partners. And even in the midst of the ongoing genocide by an apartheid regime, nowhere in the resolution is there a single mention of the genocide or of apartheid or of colonization. There is no mention of the thousands of Palestinians that are still held in Israeli torture and death camps. There is no mention of accountability for the perpetrators or redress for the victims of the genocide. And Israel is not required to meet its legal obligations as affirmed by the International Court of Justice of compensation and reparations. That responsibility in this resolution is instead handed off to international donors and international financial institutions like the World Bank in what is effectively a multi-billion-dollar bailout of the Israeli regime as it perpetrates genocide. So in sum, the resolution guarantees the full impunity of the Israeli regime and actually advances its normalization without accountability. This was a lawless resolution when held against the requirements of international law. Now, needless to say, this resolution has been rejected by Palestinian civil society, almost all political factions, all of the resistance factions. It's been rejected by human rights defenders and international law experts from around the globe. And as a matter of international law, we know the occupation of Palestine is unlawful. The Palestinian people have a right to self-determination, and they have a right to resist foreign occupation, colonial domination, and racist regimes like that of Israel. Not only does this resolution deny those rights, but it even goes so far as to buttress the illegal Israeli presence, to authorize its own mechanism of occupation and colonial domination in total breach of these international law principles. Now, I want to say something about the legality of this exercise in a bit more detail here. People who follow history will know there was a very infamous moment in television history when the former US President Richard Nixon, 3 years after he was forced to leave office in scandal, was asked by a television interviewer, David Frost, if the US president could commit illegal acts. And Nixon replied, quote, "If the president does it, that means it is not illegal," end quote. And with those words, you can see that he dismissed the very idea of Republican government handing back to, absolute monarchy and the very essence of the rule of law. For Nixon and a lot of people today, and some people and some institutions are simply above the law. Not only are they not bound by the law that binds the rest of us, but we have to follow their orders. That is the divine right of kings in which they believe. And what I've said is that, half a century later, the ideology of Nixon is still alive and well, because in the wake of the Security Council adopting Resolution 2803 last month, a resolution that has shocked all legal analysts and human rights defenders because of its blatantly colonial content, even critics of the resolution seem to have thrown up their hands to declare, oh, well, the Security Council adopted it, so now it's law. In other words, to paraphrase Nixon, if the Security Council does it, that means it is not illegal. That is nonsense. I mean, we have to recognize that indeed the Security Council is an immensely powerful institution. It is subject to very few checks and balances. It does not answer to judicial review, but it is not above the law, and it has no power to declare the unlawful to be lawful. In fact, the Security Council derives all of the powers that it has from the UN Charter. It has no other powers. And the UN Charter as a treaty is a part of international law. It is not above international law. It is not outside of international law. And that means that the Security Council must operate within the boundaries of the Charter and with the boundaries of the broader body of international law. Any actions that it takes outside those boundaries are necessarily unlawful and ultra vires. Acts of the Council that are unlawful and ultra vires cannot be said to have the force of law, and therefore there can be no legal obligation to cooperate with or comply with such acts. And indeed, I have argued that where such acts are manifestly unlawful, there may be a duty to oppose them. And many elements of UN Security Council Resolution 2803 are indeed manifestly unlawful because, one, they conflict with other key provisions of the Charter that are binding on the Security Council. They violate Jus Cogens norms of international law with which all states are familiar. So it's no mystery where the lines of international law are. And they violate rights and erga omnes obligations that have recently been affirmed with great clarity by the International Court of Justice with regard to the very same situation, that is the occupied Palestinian territory. That means the breaches contained in this resolution are not in gray areas. They are obvious, bright-line transgressions of international law. And that clarity brings a special obligation for states and others as a minimum to avoid participation in such breaches. These are manifestly breaches of international law. Now, yes, the UN Security Council is very powerful and it has gone rogue, and that is something that we should all be very concerned about in the wake of the adoption of this resolution. But there are constraints on the power of the Council. The first constraint, of course, is the veto, with which permanent members of the Council can control the worst impulses and excesses of fellow P5 members. But in this case, 3 of the 5 permanent members, the US, the UK, and France, have been directly complicit in the Israeli regime's colonization, apartheid, occupation, and genocide perpetrated against the Palestinian people. And shockingly, the other 2, Russia and China, simply stepped aside and allowed the US scheme to pass without a veto. The second set of constraints on the Security Council are the terms of the UN Charter itself, from which, I repeat, the Council derives its mandate in its entirety. And Article 24.2 of the Charter requires the Council, in discharging its duties, to, quote, act in accordance with the purposes and principles of the United Nations, end quote. Those purposes and principles are explicitly enumerated in Article 1 of the Charter, and they include, among others, the maintenance of international peace and security. That's the principal remit of the Security Council, but, quote, in conformity with the principles of justice and international law, end quote. That is the qualification on the power of the Council. Clearly, Resolution 2803 could not be said to be in conformity with justice and international law, particularly in the wake of the recent advisory opinion of the International Court of Justice, the highest court in the UN system, by the way, specifically elaborating on the requirements of justice and law in the case of Palestine, none of which are respected in the resolution. They also include, quote, respect for the principle of equal rights and self-determination of peoples, and, quote, promoting and encouraging respect for human rights. And as I have pointed out, Resolution 2803 directly breaches those principles. This despite the fact that the right of the Palestinians specifically to self-determination has been repeatedly affirmed by the United Nations and by the International Court of Justice. And a final charter limitation contained in Article 2 imposes an obligation on the UN, its constituent bodies, its member states, and the Security Council to, quote, fulfill in good faith the obligations assumed by them in accordance with the Charter, end quote. The explicit breaches contained in Resolution 2803 of these mandatory Charter principles, principles binding on the Security Council and its members, is further evidence of the illegitimate standing of this resolution. But another key constraint on UN Security Council action is the Council's obligation to conform its action to the so-called Jus Cogens and erga omnes rules of international law. These are the highest peremptory rules of international law, universally binding, allowing no exceptions and imposing obligations on all states and on their intergovernmental organizations. States and organizations of states can never derogate from Jus Cogens norms of international law. And these include things like self-determination, the prohibition of colonialism, the prohibition of the acquisition of territory by force, restrictions on the use of force, certain human rights protections, and others, all of which are breached by the terms of this resolution. The attempted overriding of several of these rules by the terms of Resolution 2803 is therefore both unlawful and ultra vires. The Council does not have the power to do this. So, excuse me one second. Right. So I want to say before I stop here that critics of the position that I'm taking now will point to Article 25 of the UN Charter. That provision says that members of the United Nations agree to accept and carry out the decisions of the Security Council. That, to them, they will say, is a treaty obligation binding on all states members. But what's often missed in discussions about Article 25 is that it is qualified with the language, quote, in accordance with the present Charter. Decisions taken that are not in accordance with the other provisions of the Charter, by definition, are ultra vires and would not meet the test of Article 25. And any legitimate obligations imposed by the Charter could only be those that are consistent with international law under the terms of the Charter itself. Others will emphasize the supremacy clause of the UN Charter that's contained in Article 103. That provision holds that, quote, in the event of a conflict between the obligations of the members of the United Nations under the Charter and their obligations under any other international agreement, their obligations under the Charter shall prevail. That sounds clear, but Article 103 applies to conflicting treaties. It does not override the jus cogens and erga omnes obligations of states contained in customary international law, many of which are transgressed by Resolution 2803. The conclusion here is clear. Resolution 2803 is illegitimate. It must be opposed. It should enjoy no cooperation from UN member states in its attempted implementation, and it should be declared null and void. But of course, those objectives face significant institutional and political hurdles. A fundamental flaw in the UN Charter is that it does not provide for formal judicial review of the Council. And indeed, a Belgian proposal for judicial review of the Council by the International Court of Justice was explicitly rejected during UN Charter negotiations. But this does not mean that the ICJ is powerless in the wake of lawless decisions by a rogue Security Council. The ICJ can consider actions taken by the Council both under its contentious jurisdiction and under its power to issue advisory opinions. And it can issue authoritative opinions and decisions on the duties of states in conformity with international law in the wake of such actions by the Council. Thus, while it cannot overturn a decision of the Council, its findings can help to both discredit and therefore erode the political authority of such actions, and can help to mitigate the harms of such actions by advising states on what international law allows and prohibits as they consider their conduct following such action by the Security Council. It could inform subsequent action by the Council, in the Council, by members wishing to comply with their obligations under international law and to remediate their earlier legally problematic positions in the Council. And other non-Security Council member states can use the findings of the court to justify non-compliance with violative elements of the Council's decisions. And such action by the International Court of Justice could also help to deter future rogue action by the Council, as UN Security Council members would then seek to avoid legal controversy around Council decisions. So too could domestic and regional courts review Council resolutions or their implementation to determine the lawful scope of action by an individual state or a regional organization. And beyond judicial avenues, the UN General Assembly could act to mitigate the potential harms of UN Security Council resolutions like 2803 by convening under Uniting for Peace. The UN General Assembly, with a 2/3 majority, could adopt a comprehensive resolution to reaffirm the Palestinian right to self-determination and the illegality of any occupation or colonization of their land, to adopt measures to hold the Israeli regime accountable, deploy protection for the Palestinian people, and to mitigate the worst elements of 2803. And it should do so without delay. And the people of the world must mobilize to press individual governments to pledge to reject the lawless provisions of 2803 and to fully implement the findings of the International Court of Justice. As the old legal maxim goes, lex injusta non est lex. An unjust law is not law. including those declared by the Security Council. The Universal Declaration of Human Rights opens with an axiomatic recognition that if man is not to be compelled to have resource as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. It's clear that the Council members did not read this before they adopted 2803. And the stain of their lawless act will outlast the tenure of every ambassador on the Council, and the damage done to the legitimacy of the Council may ultimately prove fatal. But the people are not without recourse in the wake of this massive abuse of power. There are avenues for action in the courts, in the UN, and in the streets. Popular action can block the implementation of the resolution, hold foreign ministries and ambassadors accountable, rein in the rogue council, impose costs on US imperial overreach, isolate the Israeli regime, and help to bring about Palestinian liberation. That has to be the message. Lex injusta non est lex, and this shameful resolution must not stand. Thank you.
Thank you very much indeed, Mokhiber. I'm going to turn immediately to Jonathan Whittall. Thank you, Craig. Jonathan?
Thank you, Lynn. Thanks, Craig, and thanks for inviting me tonight. Can I just do a sound check? You can hear me all right? Yeah, okay, great. Good evening, everyone. So Craig has covered a huge amount. Thanks for that, Craig. It was super interesting to listen to you. I wanted to just start by stating the obvious, which is that we're having this session, this very important discussion at a time when Palestinians continue to be killed, and the policies that now wear the mask of a ceasefire. And the pace of violence, yes, it's definitely shifted, but it's been replaced with a quieter and possibly equally harmful set of policies and practices. And some of those policies and practices exactly what we've been discussing in 2803, the Security Council resolution. It was adopted under the banner of being a peace plan, but clearly, as Craig has outlined, it entrenches occupation. It's another entry, in the ledger of failures, of betrayals to the Palestinian people. And in that sense, the resolution is not unique, unfortunately, in a long history of betrayals. But it does come at a critical moment. After more than 2 years of genocide, Gaza has become, I think, one of the clearest examples for all of us of the failure of a so-called rule-based order. The United States bulldozed this resolution through the Security Council with a kind of force that showed that a single superpower can still impose solutions, even in an increasingly multipolar era. But the fact that it did so in such a problematic way and so late illustrates the moral bankruptcy of hegemonic power. And I think in doing so, what's interesting is that Washington has demonstrated something quite familiar, which is that transactional real estate diplomacy ultimately advances settler colonialism. So at this point, I think no one can claim to be unaware of this reality, and I'll try to end this on a positive note. But I think that the clarity of the battle lines, if you like, are one of the things that we can take as a positive outcome of this resolution. So I want to touch on two things. One is what it means on the ground in Gaza, and then a bit on the contradictions as that Craig mentioned between the Security Council and the ICJ, but a bit more from a political angle in terms of how we can take this forward. So on the ground, the implications are clear and devastating for Palestinians. The resolution risks the entrenchment of this fragmentation between a green zone, a red zone, and a line down the middle that is a yellow zone. And this is one of the most damaging elements, I think, in a very long list of damaging elements that this resolution has. But it really represents the kind of solidifying the new architecture of fragmentation in Gaza. And what's dangerous is that under this logic, Palestinians that remain in the areas, the red zones, the areas that are supposedly Hamas controlled, are under the warped logic of Israel's interpretation of international law, are somehow outside of the scope of protection. And we've seen this throughout my time in Gaza for a period of 2 years. This kind of evacuation order logic, where those that don't move when they're ordered to move become ineligible for protection and are essentially killed. What will happen, as we've been told quite clearly, is that people will be screened and moved into the green zone of Gaza, where they'll be eligible for the bare necessities of survival that will be denied to people that continue to remain under siege in the red zone. So in short, the reconstruction will be happening in this green zone. And already I was hearing today there's already 3 or 4 sites that are being cleared for what is being referred to as the alternative safe communities. Another one of the great terminologies of this period that we're in. So on the ground today, we have what is starting to become institutional or governing frameworks that are taking shape. Craig already mentioned the International Stabilization Force, the Board of Peace. What's already kicked in is the US-run Civil Military Coordination Center, a CMCC, that is overseeing the reconstruction and the insufficient flow of humanitarian aid into Gaza, including discussions around the future governance of the Strip. So all of these structures, the Board of Peace, International Stabilization Force, the CMCC, they're operating under the guise of peace, but in reality, they're eroding the rights of Palestinians to self-determination. So they're very much reflective at the end of the day of what Israeli authorities have long wanted to do with Gaza and what they've said that they would do with Gaza. We've heard about plans for bubbles that would be created in Gaza, gated communities. We know that there is a desire not to have a connection to Ramallah. We know that there's a desire to maintain a fragmented territory, continued military presence, no real and meaningful Palestinian governance. So all of this is effectively now enshrined in the Security Council resolution. So at the same time, the governing structures that do exist, the public sector in Gaza, for example, is being destroyed. UNRWA, that is one of the most important providers of public services, continues to come under attack and is weakened and eroded. So instead of establishing pathways for Palestine towards Palestinian sovereignty, the resolution is creating these hollow administrative shells while the is being moved to a colonial administration. So it's clear that this resolution is entrenching occupation, and it's also clear that the ICJ has recently ruled on the illegality of the occupation. So that brings me to the second point that I wanted to talk about, which is the contradictions and what they mean. So the ICJ, as Craig mentioned, has issued very clear findings. It's repeatedly reiterated obligations to prevent genocide, protect civilians. It's ruled that the occupation is illegal, etc. And I do believe that the contradiction between the ICJ and the Security Council that Craig has also pointed out is, in a way, it underlines the problem, but also the potential path forward. Bear with me, because I do want to try to bring some hope to the discussion. We can see now very clearly the battle lines, as I mentioned in the beginning. On the one side, you have the equal application of law in a truly multipolar world. On the other side, you have double standards of a superpower in decline. And the United States can't continue to claim to be the defender of a rules-based order while they're subverting those very same rules. So the emperor has no clothes. It's very clear for everyone to see. But at the same time, there is an ongoing effort by the US and Israel to frame all of their actions as somehow legal, which demonstrates that international law still retains some political weight, if anything. So it does allow us, I believe, to see something else, which is that international law can still be used as a tool of resistance and a counter-hegemonic instrument. The problem is that states need to use it in such a way. And what we saw with this resolution is that it received very broad political support from across a number of member states. So, transactional politics still overruled principled politics. And so we're not at a point where a rising multipolarity in the world will inherently produce or reinforce justice. That's unfortunately something that was demonstrated through this resolution. But I do believe that this momentum can grow. And I think it will grow when it's combined with the rising tide of popular support, when it's reinforced with the court of public opinion, which I do believe still holds power. So I think the question in response to what we're discussing now is, how do we move from a rules-based order to a justice-based order? And I obviously don't have all of the answers to that question, but we know that without enforcement, international law is symbolic. And in the case of Palestine, unfortunately, it's a symbol of failure. But I am given hope by the coalition of states, for example, that have created the Hague Group, that are exploring enforcement options. I am given hope by the South African case in the ICJ. To be honest, even the fact that the ICC is under such intense political attack gives me some hope that it still has a continued relevance. Otherwise, it wouldn't be under such intense political scrutiny and attack. So yeah, the resolution will be entered into the ledger of betrayals, but history also has a ledger of popular will, is what I guess I'm trying to say. And the stark contradictions that we see are, in a way, a indicator of the powerful panicking. It was a scramble to legitimize what the world is increasingly understanding to be illegitimate. But the Security Council and a Security Council resolution won't put the clothes back on the emperor. So the battle lines remain. And what Gaza has shown us is that a rules-based order does crumble under the weight of double standards, but it can also catalyze movements for justice, and we've seen that with the ICJ, and we've also seen that with the very persistent global solidarity movement that's emerging. So my hope definitely doesn't stem from the goodwill of powerful states, obviously, but it does come from the fact that I think that systems that are built on a colonial logic and that are reinforced with double standards are very unlikely to survive, especially when they're so visibly exposed and opposed by not only international law, but also the court of public opinion. So I do believe that the law still has some power, even though we have clearly again been betrayed. And it has a power because states are trying to legitimize their actions by pretending to respect the law, ironically. So I think our job is to continue exposing double standards, like we're doing through this discussion, pushing and strengthening coalitions for accountability in all of the platforms that we can. And as I've been told by many Palestinians in Gaza, hope dies last. So I think that is something that we can hang on to in this case as well. I'll finish it there, and happy to engage in discussion. And thanks again for this important and timely discussion. Back to you, Lynn.
Thank you very much, Jonathan. I wondered, to start off, I'm aware that we haven't really, or you haven't, and we haven't really discussed yet the treatment of Palestinians in general in the resolution and in the how it envisages the future. When we talk about colonialism, we talk about, boldly colonial. It may not be that those who haven't read the resolution or discussions around it are quite aware of how massive is the complete ignoring of Palestinian participation in this process, in their future, in the idea of self-determination. So I wondered, Craig, if you'd like to just explain that a little more vividly to people who haven't actually read the resolution, the sort of the erasure of the Palestinian voice in any way from the future here.
Yeah, I mean, this is the most shocking aspect of this resolution from my perspective, is that it codifies a kind of 19th century colonialism. in the 21st century with, under UN auspices, which is really very striking. This is not a resolution that just on the margins, is something subject to criticism. It really is a colonial act. In fact, I said, not only is it 19th century colonialism, it's actually King Leopold-esque, because if you read the Trump plan that is referenced and annexed to the resolution, it is Donald Trump himself, like King Leopold, who has become the owner, effectively, of Gaza under this resolution. It welcomes, endorses, annexes the Trump plan. It calls on parties to implement it in its entirety. It empowers this Trump-headed Board of Peace that will serve as the colonial government, the transitional administration that governs all of Gaza. It will control all aid and services. It will control the movement of all people in and out of Gaza. It will control the framework and funding and reconstruction of Gaza. Just imagine that. We're talking about Donald Trump, Tony Blair, Jared Kushner, controlling the millions that are going to be appealed for from the Gulf and from European governments in the hands of these people that are supposed to be to the benefit of the Palestinians. It even has a broad grant of so-called, quote, any other tasks that may be required that it gives to the Americans in Trump, dangerously broadly formulated language. Up front, it authorizes Trump and his board to establish undefined operational entities, transactional authorities, and so on. It does envisage a kind of quisling body of Palestinian technocrats, but they will report to Trump, to his Board of Peace on their own land. They will be reporting to a foreign administration. It rejects Palestinian control of their own territory in Gaza until Donald Trump and his collaborators, under the terms of the resolution, decide that the Palestinian Authority, which is not even a thing in Gaza, has satisfied the reform requirements that have been set by Trump himself and by the similarly odious French-Saudi proposal that we might have a chance to talk about. So basically, the right to self-determination of the Palestinians is up to Donald Trump. And it contains no promise whatsoever of Palestinian independence or sovereignty, setting back the cause of Palestinian freedom with this vague, hyper-qualified language that Trump gets to decide when and if Palestinians have met undefined, quote, reform and development criteria, at which point, quote, the conditions may finally be in place for a credible pathway to Palestinian self-determination and statehood. And then to make sure that even that vague proposal doesn't have any meaning, any process toward those ends under the terms of the resolution has to be controlled by Trump and the United States itself. In other words, one of the co-perpetrators of the genocide will decide whether and when and how much freedom the Palestinian people are to have. The UN Security Council, with this resolution, has granted a veto over Palestinian self-determination to the US, which was the Israeli regime's chief sponsor and co-perpetrator in the genocide. And by the way, it does nothing to guarantee humanitarian aid and to turn that back on, as we've already seen. It only has language that underscores the importance of humanitarian aid. As you know, the Council is empowered to demand the free flow of humanitarian aid. It does not do so. And then it also mandates a proxy occupation force. They call it the International Stabilization Force, headed by Trump and his board in the same way that the others are. The command of this force have to be approved by the Trump board. It will explicitly operate in collaboration with the Israeli regime, the perpetrator of the genocide, as well as with the Egyptians. Even its members are to be identified in cooperation with the Israeli regime. And it has the power to, it says to secure the borders, which means to cage the Palestinians in Gaza, not to address the perpetrators in Israel. It is supposed to stabilize the security environment, by which they mean the suppression of any resistance in Gaza to occupation or apartheid or genocide, with no control over the Israeli perpetrators. It is to demilitarize Gaza, but not the perpetrator regime in Israel. It is to destroy all of Gaza's military defense capacities that they have a right to under international law, but it will not touch the defense capacities, the military capacities of the regime that is perpetrating the genocide. It is to decommission the weapons of the Palestinian resistance, but not those of the Israeli regime perpetrating the genocide. and on and on and on and on throughout. This is a force which is designed to control the survivors of the genocide and to complete the project of the colonization of Palestine in Gaza. So in other words, the mission of the proxy occupation force is to control, contain, and disarm the victims of the genocide, but not the regime perpetrating it, to ensure security not for the victims of the genocide, but for its perpetrators. And in what I think is a stunning breach of international law, it authorizes Israeli regime forces to unlawfully continue to occupy Gaza until the Trump board and the Israeli regime together decide that they want it to leave. And in any event, even with all of that, the resolution provides that the Israeli occupation forces can remain in Gaza to occupy a so-called security perimeter, which is 50% of Gaza, indefinitely. Again, a direct contradiction of the findings of the International Court of Justice. This is 19th century colonialism with a King Leopold hat.
Thank you. Jonathan, I don't know if you'd like to comment further on that, but I also wanted to ask you, I know it's not something we could ever endure, but the system of, I mean, Craig mentioned that briefly, but the system of humanitarian access that is set out under this, and you said has started to unroll already in the Strip in Gaza. Could you comment on that in terms of also as your humanitarian access negotiations and so on, with your hat on a bit, not an official hat, obviously, but in terms of the possibilities and the restrictions that that is likely to place on an already starving population?
Yeah,
I
thanks,
mean,
Lynn.
yeah.
No, it's good. It's a good point. So essentially, what it does is it codifies the existing regime of restrictions that are already in place, and enables Israel to continue to be the gatekeeper of humanitarian aid going into Gaza. So we've had, since the beginning, since October, but 17 years before that as well, a system in place where everything is, the starting point is total blockade. That's the baseline. Baseline is nothing goes in, and everything that does go into Gaza is an exception. It's a negotiated exception ultimately. And so what this resolution does is that it creates this civil military coordination center, which will report to the Board of Peace, and it coordinates, but with the exact same Israeli structures that have been restricting humanitarian aid from the beginning, the entry of assistance into Gaza. Now, the problem is that there's a number of problems. One is there's a very problematic registration process that's currently underway for NGOs in Gaza. Many of them will potentially lose their registration, so the capacity to bring in goods is being kind of slowly decimated by a very restrictive registration process that prohibits NGOs from being critical of Israel. At the same time, you have UNRWA that is being weakened, and yet they're the biggest provider of any kind of capacity on the ground to deliver assistance. You have a very strict regime of what is referred to as dual use restrictions, which means that anything that can, in the eyes of the Israeli forces, anything that can be used for military purposes is restricted, and that can be, for example, a pediatric wheelchair is a dual-use item in the eyes of Israeli forces. So are crutches, so are certain poles within a tent. So all of those items that are needed for bare minimum survival, continue to be restricted, and now are restricted within a framework of this civil military coordination center that is run by the US, but ultimately reports to Israel. So there has been an increase in the humanitarian assistance going in compared to the non-ceasefire period. But absolutely not at all the levels that it should be, and not at all the levels that are required for survival of the population. So it's really, what was happening before the ceasefire was so apocalyptically bad that anything is an improvement, but it's absolutely insufficient and continues to be insufficient.
Thank you. Sorry. Nimmer, just to let you know, I can't actually see the questions, so you might have to ask them. I have one more really thank you, Jonathan. Stood for two of you, and I guess it's also more from a international law perspective, but I think it goes to what you're both talking about. And this is the idea, if we're going to talk about what is left of international law after this, it could be also a number of things, but it could be, in a sense, what I understand from what you were saying, Craig, is that everything is left. Because this resolution cannot change the peremptory norms of international law already. So in that sense, what's of it? International law remains as it is, with all its faults and flaws, which is also another discussion that maybe we're not having today. But I mean, obviously, the particular legal studies and people have a lot of work on this, but maybe not for now. So that's what's left of international law in that sense. But also, what's left, we could be not looking at going, we don't want to go back. We do want to go forward, which is what we're talking about. We could think about going sideways, as you both talked about in a bit. If we can't get things going through the Security Council, we go to other mechanisms like the ICJ and so on. But I'm not quite sure. I'm not quite sure we've answered the question for a bit. I would like you both to talk a little bit more about your faith, in a sense. I'm coming to the questions in a minute. Your faith in a sense of the sidestep. So the idea of the global movement in support of Palestinian liberation, as you talked about, Craig, as you've also talked about, Jonathan, putting your faith in movements that are not necessarily envisaged as critical factors in the story of international law. I want to read something just very brief from Ardim Sayas, who wrote on the blog on the European Journal of International Law that there really is he's called it a paradigmatic moment in the history of the international legal order. Some will say there's situations that have happened before, but what makes Palestine different in many respects is not what is happening, horrific though it is, but rather who is perpetrating it, under what pretense, and the extent to which it uniquely belies the origin story of the post-World War II Western liberal international legal order, which I think you kind of touched on as well, Craig, in your presentation. So in essence, it is the positionality of Palestine's tormentors that affords it a broader urgency, and that's what it's all tied up with. So I don't know if you'd like to comment a little more on that and on how we sidestep that and get with it. Because everybody, of course, will be saying, yes, but how do we get around the vetoes in the Security Council, and how do we do these other moves and keep faith in those moves alive, while we also, of course, have to go to the streets? I mean, this is also something you were talking about, Jonathan. So these other factors of how you, I'll just ask you, and then we'll go to some of the questions. So either whoever wants to start first. Jonathan, you want to go first? You want Craig to go first on this one? Was my question not clear?
No, because sorry, Lynn, but I lost you for a second due to my my dodgy internet. So I'm back now, but I'll
all right, okay, Craig.
Okay, I'll see if I can provoke Jonathan. Yeah, so our problem is not a legal problem. Our problem is a political problem. International law is clear. It's become all the more clear by these over 2 years of genocide being perpetrated, live stream, the first, as everyone says, live stream genocide in history. It isn't that these things are not prohibited under international law. It is that there are powerful, lawless, rogue actors on the international scene now, and that virtually the entirety of the rest of the international community has been on its knees before those actors, right? So, as I've said in my comments here, 2803 is just a blatant breach of international law on many different levels, and yet it passed through 15 members of the Security Council. And there has been no action to remediate the damage that has been caused by it in the General Assembly or elsewhere. And the reason for this is because the world is on its knees before these rogue actions. It's not the first time. The 1930s are still in the memory of people who are alive today, when the international community failed to respond to violent rogue actors that had a lot of power. You look in Western Asia, you see that Israel has been perpetrating a genocide, an unlawful foreign occupation. It's been occupying territory in Lebanon and in Syria and in Palestine. It carried out a transnational terror attack with booby-trapped pagers in Lebanon and in Syria. It has bombed a half a dozen countries repeatedly across Western Asia in acts of aggression that violate international law. It has bombed humanitarian ships in the Mediterranean. It has attacked, commandeered, and pirated humanitarian flotillas. It has used its proxies in Western countries to persecute citizens of those countries for speaking out against the genocide. It is on a regional and global rampage, and the reaction from the entire world, meaning the Arab governments of the region, meaning all of Europe, meaning the Western countries, and the rest, even the global South, has been either complicity in supporting it in its rampage, or sitting on their hands, not daring to challenge the Israeli regime or the American empire that sponsors it. At the same time, you've got the United States, which is ruling globally by fear, that at this moment is murdering people on small boats in the Caribbean, and is preparing to wage a war of aggression against Venezuela, and that has perpetrated acts of aggression against Iran and elsewhere. And the reaction of the international community has not been that is envisaged in the UN Charter, not that is envisaged in the body of international law that's been developed since the Second World War, but to say those things don't apply to the United States and they don't apply to Israel because, and you name it, they have a lot of money, we have trade deals with them, we have defense agreements with them, we're afraid of them. And so if there is a constituency for international law and international human rights, it will either speak up now in unprecedented ways, or this nascent 80-year experiment with international law will become a footnote in history, and we will be back to absolute law of the jungle in international affairs, which is where we are now, but an assertion could change that. So we have seen little mumbles from the Hague group of states that have stepped up to say they will enforce international law. They will not allow Israeli ships to use their ports. They will prosecute Israeli perpetrators that come into their borders. They will work together to stand up to the US-Israel axis. But where are they? Where is the Uniting for Peace resolution? There are mechanisms established that could circumvent the US veto in the Security Council, could adopt a resolution with protection for Palestine, accountability measures for the Israeli regime, and reaffirmation of the rights that have been declared in the findings of the International Court of Justice. It could happen if the rhetoric of all of those member states, the supermajority that adopted a GA resolution in September of 2024, were to translate into a unified action against these assaults. You could actually see something happening to challenge this hegemonic and abusive approach of the US and this rogue violence that is being perpetrated by the Israeli regime in Western Asia. The law is clear. The enforcement is not there because of the politics of the situation, because, where is the global South of the 1960s and 70s that asserted itself in the United Nations in affirming self-determination, decolonization, anti-apartheid, the right to resist foreign occupation, colonial domination, and racist regimes, the defense of the Palestinian people, of the South African people, of the Namibian people. Where are they now? Where they are now is they have technological agreements with the Israeli regime and security agreements with the United States and trade agreements across the board. So if there is going to be a change, it's not going to come from above with governments. It's not going to come from international institutions like the UN, which has been cowed in fear into inaction, silence, and sometimes even complicity. 32 years I spent at the United Nations. I believe in the vision of the United Nations, but the shame, the series of stains that they have taken on, sometimes by design, like the Security Council veto, sometimes by abdication, the fear of senior officials and intergovernmental bodies to do what they know they're supposed to do, those are stains that will not soon wash. So I will just finish and say, we have to mobilize shame. We have to mobilize political pressure. We have to redouble our efforts at boycott, divestment, sanctions, pushing for embargoes. We have to do what we did in opposing apartheid in South Africa, even as Western governments continued to support it. The US government supporting apartheid in South Africa right up until the end of the 1980s, until the people made it impossible to sustain that. We have to push for the General Assembly to take action. We have to push for the implementation of the findings of the International Court of Justice. We have to have massive demonstrations and civil disobedience and direct action, because what is at stake here is not just the rights and well-being of the Palestinian people. They are on the front lines. And what we see happening there is now coming home. Aimé Césaire, in his discourse on colonialism, said, fascism is colonialism applied at home. And we see the unraveling of this vision of human rights that was launched in 1945 and 1948, unraveling now as a consequence of the failure of all of us and of countries around the world and of international institutions to stand up to the unraveling that's taking place. So if it's going to come, it will come from us, and we will have to compel those in power to take the steps that we are demanding in accordance with international law. They are lawless. We are the defenders of law in this paradigm.
Thank you. Jonathan?
Thanks, Lynn. Yeah, I think for me the US has been on a rampage for some time. The Security Council has failed Palestinians for eternity. So where we look for our solutions, I agree with Craig that we need to look at different places for the solutions to what we're facing today. I don't think those solutions are going to come from the Security Council. I don't think they're going to come necessarily from the institutions of the United Nations, unless it's driven by broad, kind of wide people power, if you like. I'm slightly less pessimistic, I think, in the sense that there's the difference of the current moment that we're in is that I don't think the US is any longer the uncontested global superpower. And I do think that we're in a moment of changing, global landscape of power structures that is going to take time. It's extremely messy. The global South hasn't stepped up in the way that it could and should and did in previous instances. But I don't think that's entirely lost. And as power shifts, I do think that there are opportunities in that. I do see this resolution as an attempt to, legitimize the illegitimate. I find it interesting that the US even cares about a Security Council resolution in this kind of environment where they've been the co-sponsors of a genocide for 2 years. Why put the effort into a Security Council resolution? So there is some form of panic, if you like, among the powerful of what this moment means. And I think that can be exploited by mass movements and hopefully by emerging powers. But yeah, we're not there yet, but that's certainly where I would look to.
Thank you. Okay. If it's all right with you two, we have a few questions from those participating from afar or from near, we don't know, those in the audience. I'm going to put the first one to you, Jonathan, and it says, I really appreciate Jonathan's optimism that institutions built on colonialism and imperialism won't survive. I agree in some sense, but for example, in Africa, this was after many years of oppression. Are these the timelines you foresee applying in this case?
Yeah. I mean, so I have to say, I'm usually accused of depressing people when I speak. So that's why I maybe overly went on the optimism side of things. That kind of preempted my depressive tendencies. I do have optimism that structures that are built on the combination of settler colonialism, but importantly double standards, and that are exposed. And I think that's the important thing that we're living through at the moment is the exposure of some of these double standards. And that's where I refer to the emperor having no clothes. It's very difficult for people to pretend that what is happening now is in some way a legitimate expression or in the interests of Palestinians. So there is a dropping of the facade, and I do think that is a moment in the long arc of history that points in a positive direction. The timeline that will take, I wish it would be very quick, but I fear that it's still has some time.
Thank you. We have a question. Do you have any suggestions as to what, I think you may have answered these the two of you, as to what we should demand from our non-Security Council governments for political actions they could unilaterally take. Presumably one of those is the Uniting for Peace mechanism. Is that the case, Craig?
Absolutely. I mean, what they should be doing is operating under a framework of international law. So they should be we should be demanding that they rigorously implement both the findings of the International Court of Justice and its advisory opinions on Palestine and the provisional measures in the genocide case against the Israeli regime, of which, virtually every state on the planet is now in breach. So this whole Trump plan and before it, the French-Saudi plan, were attempts to shift the focus away from international law and accountability for the Israeli regime and into a process of normalization for the Israeli regime. So up until very late this year, the principal focus for 2 years had been this drumbeat of accountability, series of advisory opinions in International Court of Justice, the genocide case against Israel, the indictment of Israel's leaders by the International Criminal Court for crimes against humanity, the findings of apartheid, the findings of genocide by every major international human rights organizations, by the UN human rights mechanisms, by every international lawyer and genocide scholar. That was the main drumbeat. And what Israel's friends rallied to in the United Nations was to try to shift away from that. Remember, in September of 2024, a historic resolution was adopted in the General Assembly that effectively codified everything that the International Court of Justice had been saying and demanded that Israel comply within 1 year or face further measures. In advance of the 1-year deadline, these states moved to shift the focus away from accountability and into this lawless approach that now has reached its lowest point with the adoption of 2803. We should be pressing governments to reject this approach and to return to the rigorous implementation of international law, the findings of the International Court of Justice, the findings of the UN human rights mechanisms, and to stand up. Where is the defense of the International Criminal Court facing U.S. sanctions? Where's the defense of Francesca Albanese, the special rapporteur of the UN, facing U.S. sanctions for standing up against genocide? Where is the defense of the Palestinian human rights organizations, sanctioned and cornered by the U.S. in complicity with its Israeli partners? There are ways that these people and these institutions could be insulated from the harms that are being perpetrated by the U.S. and by the Israeli regime, if other states could come together and use whatever measures are available for them, EU blocking measures and individual state measures and so on, to respond and to say, no, we are drawing a line here in the sand. And yes, they could demand under the Uniting for Peace mechanism of the General Assembly to circumvent the U.S. veto and to convene to adopt a specific mechanism to affirm the rights of the Palestinian people, to mitigate the harms that could flow from the Security Council resolution, to deploy protection to Palestine, and to adopt accountability measures like sanctions against the Israeli regime, a military embargo against the Israeli regime. Yes, the GA doesn't have the power to enforce those, but it can adopt them, make them legitimate, and get countries to sign on. It could monitor them, it could expand them, and so on. They could reactivate the anti-apartheid mechanisms to further isolate the Israeli regime so that it can be held accountable. They could establish an accountability mechanism like a tribunal or something else to hold Israeli perpetrators to account. All of this could be done with a 2/3 majority in the General Assembly. A place where a 90% majority has been realized in the past, including of September of 2024, to demand these kinds of changes. And that's what we should be insisting on in our pressure against governments, whether they're members of the council or non-members of the council. They all should be pressed. And we have to mobilize global shame for this atrocious act of colonialism by the UN Security Council and the complicity of our own governments, not just in that, but in unlawful occupation, apartheid, and genocide in Palestine.
Thank you. Okay, I have a few more questions. Jonathan, would you like to add anything to that, or shall I? Oh, okay. So I'm going to start with one that I suppose verges on the also It's how can we possibly still support this deeply colonial international legal order? I think we've sort of touched on that already, so I'm not sure I could add anything to it beyond the debate, but I guess that's one for you, Craig. I would say, first of all, at this moment, from my point of view, at this moment, we can still debate the international legal order and its colonial nature, and we can fight that wherever, and we can read the debates and we can participate with them if we have the qualification. But, in the end, so long as Palestinian human rights activists and activists stand up and invoke the protections that exist in this deep colonial order, I certainly feel that I will support their actions, support everything they do, and some of them have died trying to do it, in trying to invoke the protections of the existing international legal order, however poor and impoverished and colonial it is. So for the moment, in this moment, I think we don't have to support it, but we have to invoke it. We have to make it work as it's supposed to work for Palestinians, as for everybody else it's supposed to work for. That would be my answer to that. But I will invite the two panelists to add if you wish to, and if not, we'll move to another question.
Yeah, I think it's a really important question. It comes up often in these discussions. And I think, first we can begin by recognizing that the international order is inherently imperial, colonial, and deeply racist. No question about it. But I think we would be fools to leave those weapons in the battlefield and not to pick them up. The tools of international law have been used for decolonization, for accountability of perpetrator regimes, for combating apartheid, for defending Palestinian rights. They have been used for the cause of good, for the advancement of a decolonial agenda. And the fact that they exist, for us not to use them in that struggle, I think, a struggle where we have to use everything available, that would be foolish. The old saying that, the master's tools will never be used to dismantle the master's house. Maybe so, but if I hit the master in the head with his own hammer, it might, give me an advantage. So I think, we have to look at those experiences, the anti-apartheid movement, the decolonization movement, and how those movements used those international law tools to advance their cause. Yes, it wasn't only that. They used armed resistance as it was their right to do. They used global solidarity and boycott and divestment and sanctions and mass demonstrations and so on, as was the, I think, ethical obligation of all of us to act in solidarity in that way with Palestinians and others that have been subjected to this kind of oppression. But they also used international law. And I would just conclude by saying this: everywhere you look in the international body of law, the law is on the side of the Palestinian people. And that's why the US and the Israelis and other complicit actors work so hard to attack legal institutions and human rights mechanisms and those who are using it, because they know neither in the court of public opinion nor in a court of law can they prevail. Those tools are ripe for us. And, I became a lawyer far too many decades ago, not because I wanted to contribute to the status quo, but because there were lawyers who convinced me, people like Bill Kunstler in the United States, Ralph Nader and others, that law could be used as a tool of social change, not just to defend the status quo, but to dismantle it and to fight for justice. It is imperfect, but I think it would be foolish to leave it on the battlefield.
Thank you. I have one. Unless you wanted to add, Jonathan, this is one focus more on the students. What hope is there for the younger generation to enter human rights law through organizations like the UN? Are there better avenues for us to be a part of the changing space in law? And there's also what can students do now to help outside of protesting? But I think the idea of the space for the younger generation to feel that they have a contribution to make might be, although you didn't do law, but you might be able to answer some of that, perhaps, or all of it, probably.
Thanks, Lynn. Maybe just to add on the previous one as well, I think for me, and you touched on it, Craig, but law cannot be our only tool. It's one of the tools. It's imperfect, and if it's used in combination with multiple other tactics, and South Africa, Oliver Tambo had his 4 pillars of the anti-apartheid struggle. Law can even feature as an explicit part of that, but it kind of was a through line that was used to mobilize. And I think it's a useful tool to expose double standards and to generate some of that shame that is then useful for other for other things. In terms of what hope for, so yeah, I'm not a lawyer, so I won't pretend to advise on the future of law students, but I can say that I do find inspiration in some of the tactics that are being used by, for example, the Hind Rajab Foundation, that are using law in a really interesting way to, yeah, and I'm sure many of you are aware of the work that they're doing. I think the UN needs people that see the law in the way that is being discussed here today. I'm not sure what the future is of the UN in accommodating these kinds of perspectives, but I don't think it's an institution that necessarily we need to or should yet give up on in its entirety. But yeah, so there are definitely other ways to engage. I think, you know, protest and these kinds of discussions are important. I think, you know, I think it's important to hold our elected officials to account, and I think that's something that we need to be doing in all of the places where we live and operate. I think one way is through protest, but the other way is through the ballot box. And I know that that's maybe a longer term perspective, but I do think that the more Palestine becomes a domestic political issue, the more progress we'll be able to start seeing on some of these issues, and that is, you know, possible through the kind of mobilization that happens on campuses like SOAS and other places. Back to you, Lynn.
Yes, thank you very much. Craig, did you want to add to that?
No, I think that was perfectly said. Thanks.
Yeah, because of course it was an issue in the mayoral elections in New York. So I mean, I presume that's something that you would be looking at there. I'm going to combine just a couple of questions. One was about whether anybody knows whether any of the states who voted for this resolution, not necessarily permanent 5, but the others as well, whether there's any indication that they are regretting their mistake, or whether they regret, I should say, whether they're regretting their action. The other one is whether there are any discussions and possibilities of changing the permanent 5 or removing the veto. Anybody want to answer that?
I can say something about that, I guess. No, there's very little, if any, chance of changing the P5 or getting rid of the veto. And, you know, the veto is a mixed bag. You know, 2 years plus of a genocide, they couldn't get a ceasefire through because it was repeatedly vetoed by the US. But when a veto would have actually protected the rights of the Palestinian people, that is for 2803, there was no veto to be found. So the veto is very much a mixed bag. The P5 is a horrific problem. It is, you know, by design, the kind of problem that is manifest here. It was the victors of the Second World War who created that mechanism and effectively put those 5 powerful countries above the law because they can veto anything they don't like vis-a-vis themselves or their allies. You know, and, you know, there are all sorts of proposals for reform of the Security Council that have to do mostly with expanding the security. Remember, the P5, there's not a single African among the P5 or a Latin American or, you know, so, but all the proposals have to do with expanding members, but you don't get around the privilege of the P5 by making the Security Council bigger. It may be better in some ways, but it's not going to answer it. No, I think that, you know, you have to look at that. I think that all of the members of the council, permanent and otherwise, knew perfectly well what they were doing when they gave this colonial grant to the United States, to Donald Trump. This was Donald Trump's plan. It was ridiculed by all right-thinking people in the entire world when it was adopted. But what happened in the Security Council was that the US deployed, according to diplomats in New York, the most extreme threats and inducements it has ever deployed. And that is a standard part of US diplomacy, is that, you know, US diplomats are often not the most skilled diplomats because they don't have to be, because they have power. So they always deploy those threats and bribes in order to get states to vote the way they want them to. But the message out of New York was that they'd never seen it as extreme as it was in this case, and everything was on the table. Trade deals versus tariffs, you know, sanctions versus recognized relationships and so on. Russia and China that could have vetoed it. Russia was in the middle of negotiations with the United States on Ukraine. And you will see that as soon as this resolution was adopted, there were leaked details of what was being discussed between Trump and the Russians that had to do with territorial releases in Ukraine to the Russians. China was in the middle of sensitive negotiations with the Americans on trade and tariffs, and at exactly that moment, the Saudis, who were a major actor in trying to mobilize support for 2803, were in the middle of negotiations, and the outcome of that announced as soon as they left that they're talking about making Saudi Arabia a major non-NATO ally, which means that the US would guarantee the regime's security, and negotiations on advanced fighter jets to go from the United States to the Saudis. Egypt, very active in promoting the resolution, as well as the second largest recipient of US foreign aid and very much a client state vis-a-vis the United States. So all of these threats were, and then on top of all of that, what the US did, and very openly, as they said, if you don't agree to this, we will unleash the dogs of genocide fully. We will support Israel in continuing the full-scale military assault on Gaza. If you don't agree to this, it's all over. And then you had the Palestinian Authority, which is, operates under occupation with the Israeli boot on its neck, under the American thumb, relying on money from the Europeans and from the Gulf, an extension in many ways of the occupation in the West Bank, that also was instructed that it had to support this and told allies when they were asked, yes, you should support this resolution. It's what I called a perfect storm of complicity. So if you ask me, do some of these states regret their vote on the Security Council? I'm sure some of them regretted it as it was happening, but not enough to actually stand up for principle, for the rights of a genocided population, or for their obligations under international law. And if there's going to be a counterbalance to that, I say it again, it's going to come from us. We have to shame every one of those 15 members and every state that has been sitting on its hands through over 2 years of genocide in Palestine.
Okay. I have one last. Jonathan, did you want to add to that one? No.
No,
Okay,
no,
this is
fully agree.
I think, me too. I think this is probably going to be the last one, and it's to both of you. And I can think of several answers, but what role can those working within the institutions and agencies of the United Nations play to uphold international law and avoid complicity while serving the critical humanitarian and reconstruction needs of this time? There are several questions in there, but yes, who wants to take that first? Jonathan, you want to take that one first?
Yeah, sure. So I mean, I think there's a critical role of those within these institutions to continue, to continue to try to steer things in a direction that is in the interests of Palestinians. I as many of you may know, I was kicked out of Palestine because of some of the public communications that I was doing. And I think that's something that I would hope to see continue from other others within the system, within the UN system. I don't have a lot of hope in it, but I do think that it's something that those that are part of these structures and these institutions can continue to raise the voice and push the limits. I mean, we're dealing with imperfect institutions. I think we've established that. We're also dealing with imperfect tools. The parameters are not always to our advantage that we have to work within. But I think it's the responsibility of every person that are working within those parameters to continually push the limits, to find ways to expand those parameters in the interests of Palestinians ultimately. So yes, there is a role. These institutions are going to play a critical function in different ways. If they are left to purely being the implementing arm of resolutions such as this one, without any voices from within challenging that and trying to to push the limits. I think it will be more dangerous than it is currently. Having said that, it's extremely difficult to do. So, you know, I did it and I was kicked out. So it's not exactly a recipe for immediate success. But I think it's an obligation.
Thanks, Jonathan. Craig, you have 2 minutes or 1 minute. I have to no, I think I might have to close. I'll give you 1 minute and then I will thank everybody and close. Sorry.
I'll take that 1 minute by saying two things. One, remember those people in the UN who have been doing the right thing in the face of tremendous pressure from inside the organization and outside the organization. Here I'm talking about the International Court of Justice. Here I'm talking about the human rights mechanisms like the special rapporteurs like Francesca Albanese, who have continued to do their jobs in the face of enormous pressure, even official US sanctions, death threats, harassment by Israel proxy groups, and so on, or the people in UNRWA. Hundreds of them have been murdered in the genocide while serving their neighbors, many along with their families. So at the very least, wherever you are, whether it's inside the UN or outside, you have to speak up. You have to take risks. You have to say that this is not normal. I will not allow it to continue in my name. Don't leave your ethics at home. That have to be a part of what you're doing. And if you see the heroism of the people of UNRWA and the courage of the special rapporteurs of UN system and so many staff who are standing up against their bosses, who have lost their way. The political corridors of the UN have lost their way. They have given in to pressure from the US and the UK and Germany. They've given in to harassment from Israel proxy groups. Our voices have to be louder than the pressure on the negative side, demanding justice, respect for international law, and freedom for the Palestinian people. They cannot continue this unless we are all silent. So wherever you are, speak up.
I think that's a very good place on which to finish. I don't know who sent that question, but that was I think a very good question to finish on for our two panelists, both of whom have taken stands and are speaking up. So thank you very much indeed to Craig Mokhiber and Jonathan Whittall. It was an absolute pleasure. As I said before, in these very bleak days, having a time when one gets inspired is always good for the soul and the morale and the courage. So thank you both very much. Thank you, Nimr, for instructing me. You had no idea I was having my strings pulled by Nimr on the side. No, I wasn't really all the time, but he is there. And thank you. And to all of you out there who are still there, thank you for accompanying us. Thank you for your questions. I hope it was helpful, useful, inspirational, informative. Thank you to the Centre for Palestine Studies. And I suppose we should say good night, good morning, goodbye. I don't know in what time zone people are watching us, but thank you all very much. And may we see better times for Palestine and freedom for Palestine. Bye, everybody. Goodbye.
Thank you.
Bye-bye.
Thank you, everyone.